Of the Environment, Climate, and Legacy Committee to order. And let the record show that it is 3:05 p.m. on Thursday, February 20th, and the year is 2024. We're still await for quorum. We'll announce that as soon as we have the number. There's 4 items that we're going to deal with today. First is Senate File 3345, Senator Mitchell. Then we'll get an update from Bowser. Following that will be a bill that I carry. Last on the list is Senator McEwen's bill, 3728. And so look like Senator Mitchell already ready to go. And so welcome, Senator Mitchell, to our committee. Ready anytime, introduce yourself, the bills, and your testifiers. And we'll go ahead. Looks like you have an amendment as well, right?
Yes,
Okay.
Chair.
Okay, we can't move it till it's quorum, so perhaps you can talk about the bill.
Absolutely.
And as soon as we have quorum, then we'll ask you to make a motion. We'll make motion for the amendment. Thank you.
Thank you, Chair Herr. So I'm here today to discuss Senate File 3345, which would phase out the sale of mercury-containing fluorescent bulbs. Mercury is well known as a toxin, and it has dangerous effects, particularly for pregnant people and for children. I'm so proud of our history on this issue in Minnesota. In 2007, we were the first state to ban mercury in cosmetics, and especially as the land of 10,000 lakes, of course, we want less of these toxins in the environment, not only hurting people, as we mentioned, women and children, but also getting into our waterways and other things that would hurt our natural resources. So today, consumers and businesses have thousands of readily available LED alternatives to fluorescent lamps so that we would not have to use that mercury anymore. They're more cost-effective, longer lasting, already providing light in many of the places that did used to use the mercury-based lighting, and of course, more environmentally friendly in a number of other ways, including the reduced energy cost. If I may at this time, since we're waiting on moving the amendment, I would like to have my testifier go forward, Joseph McCleany.
Yeah, you may introduce yourself.
Hi, my name is Joshua McClinney. I work for the Appliance Standards Awareness Project. I'm here to speak in support of SF 3345 and reinforce that LED technology is affordable, reliable, and ready to go. ASAP published a report in 2022 evaluating the lighting market, asking that very question, are LEDs ready? We found that the answer is yes. They are now widely available and cost-effective as alternatives to fluorescent bulbs. We found that LEDs are twice as energy efficient. They last 2 to 3 times as long as fluorescents. And of course, they don't contain mercury by design. Not only did we find that LEDs are ready to go operationally, but they're widely available. LEDs are designed to be drop-in replacements for fluorescents. In most cases, you can just take out the fluorescent and pop in an LED. We found that LEDs are better for folks' back pockets. They've come down in price dramatically in the last 10 years. Statewide, ASAP calculates that by 2050, Minnesota could see more than $500 million in utility bill savings from transitioning to LEDs. The most common type of fluorescent light bulb is the 4-foot T8. We found that LED replacements on average cost just 11 cents more per bulb, and that 11 cents is recovered in less than a month due to utility bill savings. Since 2022, 7 different states have passed nearly identical policies, ending the sales of common fluorescent light bulbs because of the findings that LEDs are now widely available and ready to go. I hope Minnesota will join them. Thank you.
Thank you, Mr. McLean. And looks like we have quorum now. Senator Mitchell do have a A2 amendment that she'd like us to make a motion on. And so I'd like to have Senator McEwen moves that A2 amendment to Senate File 3345 to be adopted. Okay, all right. All in favor, say aye. Aye. Opposed? Okay, motion prevail. And Senator Mitchell, you're represented to your bill already, and also hear a little bit about test from Mr. McLean. Any additional remarks?
Yes, Senator, Chair Herr. Thank you. Just so people know, the amendment, we actually dropped this at the end of last session, but it wasn't until it got on the schedule that some of the stakeholders came forward. So the amendment is mostly just adding in definitions and making the language a little bit more clear. I would like to add, I need to, on the amendment page, line 1.27D, I would like to, if anyone would be willing to offer an oral amendment, we would like to strike the word public. That was just a drafting error, so that it would apply to all utilities and not just public utilities. And then if that were to pass, this would be completely in order as we want it to move along.
Okay, I'd like to have Ben say, to make a remarks on that.
Mr. Chair, members, the amendment would be to the A2 amendment on line 27 of page 1, delete the word public.
Mr. Chair, I have a question.
Yeah,
Because we have
yes,
already
Senator
moved
McEwen.
the adoption of the A2 amendment, is it okay that we're just amending now? I just wanted to make sure that it's not, we shouldn't just be amending the bill as amended.
Yes, we are. Mr. Stanley, why don't you answer that?
Mr. Chair, Senator McEwen, yes, you could, before you had adopted the A2, you could have incorporated this amendment into that amendment, but since you've already adopted it,
Right.
the proper way to do this is just to amend the A2 amendment. So the fact that you're amending an amendment that was already adopted doesn't, you don't need to word it any differently. You would just say you're amending the A2 on line 1.27 by deleting the word public.
Okay. I move, Mr. Chair, if the chair is ready to entertain that oral amendment, I would like to move to strike the word public from line 1.27 of the A2 amendment.
Okay, all in favor, say aye.
Aye.
Okay, opposed, nay. Motion prevail. Okay, now we're on a formal roll now. So go ahead, Senator Mitchell.
Thank you, Chair Herr. As I said in my remarks, I just think this is a really positive step forward. We all know the dangers of mercury, both for our people, our waterways, our environment. Most places are already moving to LEDs. It is a pretty seamless transition for us, and it doesn't create really much of a burden. It just says, as we go forward, this is what is going to be offered, so that as the light bulbs burn out, so to speak, then we can start replacing them. So I think this is common sense legislation, and thank you for your time in considering this today.
Okay. Senator Green.
Thank you, Mr. Chair, and just a question for the bill author. You mentioned that the stakeholders were all on board. Who were the stakeholders, and is there any opposition to this at all?
Senator Mitchell.
Boy, there's a list.
Or Mr. McLean.
We have worked with, in addition to agencies like Appliance Standards Awareness Project, a couple environmental groups, and the MPCA has also assured us basically that they have the facilities in place to make sure for the disposal and transitions and things of that nature. I am not aware of opposition.
Okay.
Okay, any further questions? Okay, looks like we're good to go. Now, I'll move that Senate File 3345 as amended be recommended to be referred to the Commerce Committee. All right, all in favor, say aye. Aye. Opposed, nay. Okay, motion prevail, and congratulations.
Thank you, Chair.
Okay, thank you. So next on our agenda is getting information update from the Board of Soil, Water, and Resources, or short as Bowser. Just like to call testifier, Mr. Director John Jensky, and Andrea Fish. Welcome.
Good afternoon,
Please.
Mr. Chair and members. I'm John Jaski, Executive Director with the Board of Water and Soil Resources, and with me is Andrea Fish, our Assistant Director. I'm going to have her do the presentation on the implementation aspects, and I'll be here as well. Then I'll come back when, Mr. Chair, your bill is up and help you with that. Thank you.
Okay, go ahead, Ms. Fish, go ahead.
Good afternoon, Mr. Chair and members. My name is Andrea Fish. I'm an Assistant Director at Minnesota Board of Water and Soil Resources. As Executive Director Jaski noted, we're here today to talk about how we are moving forward with implementing some of those laws that were passed last year during the 2023 legislative session. There is a handout in your packet that has the PowerPoint presentation as well. A lot of the funding that went into law last year really reflects Minnesota's evolving conservation approach to be holistic and proactive and really look at things on a broader basis and a long-term basis as well. Last year was an exciting year for conservation delivery in Minnesota and for some of the funding and investments that we received both from the state and from the federal government. We're moving away from our former approach that was more based on a responsive approach to requests, reactive, competitive grants and one-time funding perhaps. And our new approach implements partnerships and puts watershed-based implementation funding toward higher priority needs within a watershed district and reflects a more strategic approach, something that is prioritized, targeted, and measurable. We're also moving a little bit past our former approach of local collaboration and two-year grant cycles to local and regional collaboration, again, on that larger scale within regions, within watersheds, and having four-year cycles for certain grants and more non-competitive grants. The scope of our work is expanding, as well as the work of our local partners. Some of the highlights of last year's legislation included funding for soil health, water storage, and pollinator habitat. In 2023, Bowser received funding from both the state and federal government for soil health practices within Minnesota. We're taking a phased approach to using these funds to direct local conservation delivery. Our first request for proposals opened on November 15th and closed on February 8th. This first attempt at proposals for local governments was intended to support additional local capacity, staffing, and increasing soil health-related expertise so that we can launch into the next phases of soil health delivery. We expect the next round of funds to be allocated in winter and spring for staffing, practices, and outreach, with a minimum of $4 million to be awarded. As we move forward with delivering on soil health practices, we will eventually be able to focus on practice implementation and direct landowner incentives. And a lot of that funding will also come from federal grants from the NRCS. We've had an additional RFP that opened in December that we think will be able to target 8 to 10 soil and water conservation districts to help prepare soil and water conservation districts so that they can help landowners and so that they can receive incentive payments. On the water storage front, $17 million that was allocated from the general fund is also recently opened for grant applications across the state. We're focusing those grants on water storage capacity where that can be increased, controlling water rates, so both the flow and quantity of water, and protecting critical infrastructure across the state as well. We're trying again with the presentation, and there it is. Thank you. And finally, the pollinator habitat that we are implementing through lawns to legumes, habitat-friendly utilities, and the Habitat Enhancement Landscape Program. This funding last year has expanded on programs and projects that were already underway. In Minnesota, as of today, we've had more than 5,000 projects installed across the state in all 87 counties. We have also had 32 demonstration neighborhood grants awarded, and we're continuing to expand that program to build pollinator pathways in critical areas of the state as well. As you know from last year's presentations, a lot of this money is also used to provide financial and technical assistance and expertise to establish habitat on existing conservation lands, such as some of our existing easements. And our Habitat-Friendly Utilities program will provide financial and technical assistance to establish habitat within solar, wind, pipeline, and electrical transmission corridors across the state. Finally, I did want to highlight a little bit about our watershed-based approach that we have come before you to talk about as well. The former approach, of course, being more local government-centric in terms of having counties, watershed districts, and soil and water conservation districts maybe working more separately and moving toward this watershed-based approach regionally. We've had significant funding for watershed-based implementation in the last few years, and we expect that the Clean Water Fund will continue to support these activities on that basis. Funding goes all throughout the state, all watershed districts in outstate Minnesota, as well as within the metropolitan area. And before we move on to the next parts of our presentation, wanted to make sure if you had any questions, we could address those today.
Any question from members? Senator Green?
Thank you, Mr. Chair. I will more than likely have more questions later, but you mentioned that the $13 million available for future direct payments to landowners, and then also on your pollinator one as well, for solar within pipelines. What kind of stipulations come with this funding for the local private landowners?
Ms.
What
Fish?
strings are attached?
Ms. Fish, go ahead.
Yes, for the lawns to legumes program, is that correct?
No, well, you can do that one too, but basically, if you go to page 7 for the soil health funding and climate smart agriculture.
Yeah, Mr. Chair and Senator Bean, I can probably cover that one since that's a soil health provision that you're talking about. Yeah, we use a conservation contract with the landowner. These are voluntary agreements that have some duration that varies somewhere usually between 1 and 5 years, depending on the parts of the program the landowner's interested in. It'll also be somewhat dependent on what the USDA funding conditions are, because we're putting state and federal money together.
Senator Green?
Mr. Chair, but I guess the question is there a list or is there a place I can go that when someone signs up for this, obviously there's a list of requirements that they're going to have to follow and probably some fines or penalties if they vary from that. So what is the policy there?
Mr. Chair and Senator Green, there's a list of practices that are in a docket that USDA provides, and we pretty much follow that same thing. And so let's say they're going to put in cover crops, there's a docket that says, the timing and the seeding rate and things like that are in that contract, and they just do that. We have, a very infinitesimal amount of non-compliance.
Okay.
Okay. Any other question? Okay, thank you for that presentation on the implementation of Bowser. So next on our agenda, I'll be coming over there to present my bill, Senate File 3559, and I'll pass the gavel to Vice Chair Senator McEwen.
Thank you, Senator Herr. So this is Senate File 3559, and I understand that you have an author's amendment?
Yes, Madam Chair, I have an author amendment, the A2 amendment.
Okay, and members, the A2 amendment is in your packets. Give people a chance to look here quick. Senator Herr, would you like to speak to the amendment or make a motion to move it?
Madam Chair, I'd like to make a motion, and I move that we amend Senate File 3559 with the A2 amendment.
Thank you, Chair Herr. Senator Herr moves the A2 amendment to Senate File 3559 be adopted. All those in favor say aye.
Aye.
Aye. Opposed, no. The motion prevails. Senator Herr, to your bill.
Thank you, Madam Chair. Senate File 3559 is a bill containing housekeeping and updating provision for the Board of Water and Soil Resources, or BOWSR for short, that help maintain environmental protection through the work of the agency and local government partners. Housekeeping provision include updates for the voluntary reinvestment in Minnesota, or RIM, Conservation Easement Program, Soil and Water Conservation District, and Watershed Districts. These updates recognize the evolutionary changes over time and will provide opportunities for the agency and for watershed districts and soil and water conservation district to do their work more efficiently. The bill also includes provision to maintain Minnesota's current level of wetland protection in acknowledgement of reduction in federal Clean Water Act jurisdiction that resulted from a recent Supreme Court decision, while at the same time helping to simplify state requirements for landowners and the local governments to help implement the state law. Director Jeske and representative for the Soil Water Conservation District and Watershed District will help us walk through the various elements of the bill.
Thank you, Chair Herr. Mr. Jeske, we look forward to hearing your testimony. Thank you.
Yeah, thank you. Thank you, Madam Chair, and thank you, Senator Herr, for carrying this bill. It represents a bundling of several agency bills that we had been working on, and so I think for the package that you're going to see in front of us, they're related things, but they're also quite independent from each other as well, and we'll make sure we point that out. With that, Madam Chair, I can just start walking through the pieces of the bill, and we've also got other, as Senator Herr indicated, testifiers regarding the Soil and Water Conservation District provisions and then the Watershed District provisions. So I'll just go in order. And I'll try and note the bill as amended. So the first section is actually repealed in this amendment, so that's no longer in play. On page 3, section 2, this provision would identify the Minnesota Public Drainage Manual as a important piece of work that we have in place now and put in place a responsibility to continue that work for the agency in cooperation with stakeholders that are part of the drainage work group. If you turn to page 4, I'll turn it over to Ms. Vanny from the Soil and Water Conservation District Association to walk through the Soil and Water Conservation District provisions.
Thank you. If you'd introduce yourself again for the record, I look forward to your testimony. Thank you.
Thank you, Madam Chair. Sheila Vanny, I'm the Assistant Director with the Minnesota Association of Soil and Water Conservation Districts, and I want to thank Chair Herr for carrying this bill. The sections that relate to Soil and Water Conservation District law in 103C start at Section 2 as amended. So Section 2 deals with updating the soil and water conservation policy. Right now, it's in 2 different places in statute, one in 103A and here in the SWCD statute. Later on, you'll see a repealer that takes it out of 103A and just keeps it at home in 103C with that update on soil health definition. Section 4 just takes the BOWSR rule out of our decisions on where our offices are located within the SWCD. A bunch of, conforming changes in Section 5 and 6. Section 7 takes out reference to 103A and changes state agency to public agency. Section 8 changes again, the reference to 103A gets stricken, and more expansive reference to our statutory responsibilities. Section 9 on our acquiring and maintaining property changes the references to 103F, .401 to .455, which are the soil erosion components of 103F, and broadens that to relate to, more broadly, to our statutory responsibilities in general. Section 10, just some cleanup language relating to our statutory responsibilities. And likewise in Section 11. Section 12 makes some amendments to, our voluntary role with developing comprehensive plans. And soil and water conservation districts currently may do those on a voluntary basis, but they are not currently required to go through a notice and comment public process. So this brings those elements into our comp planning work and brings them on equal footing with other LGU comprehensive plan efforts. And then if we look to section, what's now, what was section 13, assuming other conservation projects, again, this is cleanup language, changing state agency to public agency, referencing our statutory responsibilities more broadly. Likewise with the next section. And then on the compensation for work or projects, currently we have the authority to seek compensation from landowners for our work on extending those benefits. This adds that the elements of operations and maintenance that go along with those projects could be subject to compensation as well. The next is more cleanup language on changing state or it adds state or to the federal assistance that we have agreements on currently with conservation partners. All of section 6, what was 16, relates to those changes. And then if we look to section 17, we're removing the word board. The district shall annually present a budget. Those are some conforming changes. And then a new provision is added at subdivision 21, water and soil resource management. A district may initiate, construct, operate, and maintain water and soil resource management practices, programs, projects, and systems within the boundaries of the district. So that is not necessarily a new power or duty, but it is restating elements of existing powers and duties in probably a more modern way. And then lastly, on the 103C changes, we add a provision that gives the SWCDs the authority to take out loans. Currently, they do not have that authority, and that concludes the 103C changes, Madam Chair.
Thank you very much. Before, is this pertaining to this?
Do section by section for questions or wait till the end?
I'm going to check with our bill author to see. Senator and Chair, do you have a preference? I know yesterday or in past sessions, you wanted to do it as we went with a bill like
Yeah.
this. Is that still what you would prefer?
Yeah. I think
Okay.
that would be the ideal.
Very good. Senator Green, then, to your question.
Thank you, Madam Chair. And I think because this is a Bowser bill, I probably won't direct the questions to the author, but maybe to either of the testifiers, if that's all right. Unless you want to answer them, you can. We can just jump back here to, on the original bill, because that's what I'm going off of, on page 5. You're really opening up the jurisdiction here. When you say this is to fulfill statutory requirements. And throughout this bill, it's in here, so this will probably take care of all the questions, but these statutory statutes that are in here, actually, if you read them, they're put in there to limit you know, what the agencies can do, I believe. And so there were specific things that they can do. And by opening up to just other statutory responsibilities, is this really necessary? And how much expansion is this going to be on the authority of Bowser?
To Senator Green's question?
Yeah, Madam Chair and Senator Green, on those specific instances, the way this is structured is that the Soil and Water Conservation District statute is in 103C chapter, but there's other responsibilities that come through appropriations and other things and from other parts of statute. For example, we heard earlier about the Clean Water Fund, right? That's under chapter 114D, and so that is a responsibility that soil and water districts have when they get appropriated the funding. And so this doesn't provide any new authorities. It just simply makes sure we're acknowledging the authorities that exist elsewhere in statute beyond just this 103C chapter, including 103B. I can give you some more examples if you like, 103F, et cetera.
Senator Green?
Madam Chair, thanks. And I guess I see what you're saying, but I don't necessarily agree with you, because when these were put in place, there were specific statutes that this law pertained to. And other statutes may not pertain to certain things within the purview here. And that kind of worries me. And I will say that I'll be looking at this closer before it gets to the floor, because I haven't gone through all the changes in the amendments, and so I apologize for that. But the other statutory authority is everywhere in here. And then the plans may include, but just one other question here before we move to the next one. You have deleted something on page 7, starting at line 8. And in this paragraph here, it actually says that the work plan should be for high priority erosion and sediment and water quality problems in the district. So you're taking out the high priority. Why would you do that?
Madam Chair, Senator
Yes.
Green, this is actually kind of more of a technical change. I appreciate the focus on, erosion and sediment. Those are still important things to pay attention to for soil and water conservation districts and others. But last year, there was a change made to 103C.501, which is where this is tied back to. And that change was to adjust their conservation contracts program, which we talked about a little bit earlier, for them to use that across any of the programmatic and appropriations that they receive. And just, it's a method to work out an arrangement with the landowner to do a voluntary practice with a cost-sharing approach, right? That's what that whole program is about. So this is just removing something that is no longer relevant because of that change last year.
Senator Green?
Okay, well, we had some issues with a lot of changes last year. I mean, one more question for you. What is the object of taking state out in many places and replacing it with public agency?
Sure. Madam Chair?
Yes, please go ahead.
And Senator Green, it's really just because it provides a cooperative arrangement that's possible with other organizations like regional entities, like local governments, and so it just provides that opportunity to work with whoever their partner may be, because as you know, soil and water conservation districts don't have their own funding, so they're reliant on state, federal, and other local authorities to work on a partnership basis.
Senator Green?
So, thank you, Madam Chair. So really what this is doing is it's opening up what was probably at one time pretty much exclusive Bowser, along with SWCDs and watershed districts, and pretty much taking all the other agencies and lumping them in there as well, as far as regulations.
Mr. Jeske?
Madam Chair and Senator Green, this, it really just says it's for doing, voluntary conservation projects, right? I mean, if they have a regulatory role, that cannot be delegated. They work with, like I mentioned before, many municipalities and other local government partners, counties, et cetera. So I think that's probably the primary one that we'd be looking to make sure was included.
Senator Green?
Thank you, Madam Chair. And that's a good explanation, but it doesn't really say that in here, and it looks pretty broad. And then on page 8, line 10, you've taken out when it comes to making decisions, basically, you've taken out supervisors and replace it with district. How does that work? I mean, if a supervisor's not making it, who else define district for me, I guess. How's the district going to make a decision?
Mr. Jeske?
Yeah, Madam Chair and Senator Green, the reason we are suggesting this change is because the term district, as you just described, is actually statutorily defined to include the board and the whole organization. So the board of the district that's elected is the primary decision maker on all things that organization does.
Senator Green,
Well,
follow?
just a comment then, because districts include, in my area anyway, many different counties and a lot of different county boards. And so the district is wide. And it looks like what this is going to do is even more so put the final decisions back in the hands of Bowser. And the only thing you're really going to be getting out of your SWCDs, if the new law passes, and your watershed districts, is a funding source from taxpayers, because you're making all the decisions. And that also goes down to 824, where it talks about used to be determined by the secretary or other designated authorities, and now that's stricken. And so who decides there? And so it's it looks like we're going the wrong way on these bills, but I'll wait till to move on. Thanks.
Thank you, Senator Green. Any follow-up before we move on to our next testifier?
No follow-up, Madam Chair.
Okay. Next, on my list here to testify, we have Lewis Smith. Welcome to the Senate Environment Committee. If you'd please introduce yourself for the record, and we look forward to hearing your testimony.
Thank you, Madam Chair. I'm Lewis Smith. I'm here on behalf of Minnesota Watersheds and the Red River Watershed Management Board. By way of background, I'm an attorney working with watershed districts over the last 37 years or so. I also teach water law at the University of Minnesota Law School. We're pleased to be here. The first thing I want to say is that we should be proud as Minnesotans of the Watershed Act, which this legislature enacted in 1955. And it has served us well as a model of local government focused on protection of water resources where local people have wanted such a watershed district to exist. But since 1955, there have been a number of changes we've identified to improve the work and update it. So we want to thank Senator Herr for carrying this legislation, and we'd like to thank the Board of Water and Soil Resources for partnering with us in this process. The housekeeping changes that are before you, and I'm speaking to sections 20 through 57, which are the amendments to Minnesota Statutes Chapter 103D, the Watershed Act, do not involve any significant changes in policy or fiscal impact or any new authorities to watershed districts. These are all changes to bring internal consistency to the statute, to clarify some ambiguous terms, and to bring some processes more up to date or to bring clarity. And they fall into some general categories of improving governance procedures for watershed districts, for clarifying the planning process and updating the planning process, and then finally simplifying and clarifying the project initiation process so that watershed districts can deliver projects on the ground to improve and protect water resources more efficiently. I'm pleased to go through section by section, if with the committee's indulgence, if that is in order.
We'll ask the lead author of the bill. Senator Herr, would you like to proceed section by section?
That would be ideal, but if it could keep it as summary, short, brief as possible, that would be ideal.
Okay, very good. Mr. Smith.
Thank you. With that encouragement, I will be brief, and I note that your Senate Counsel has offered a very efficient summary as well. We begin at section 20, where we're changing and expanding the understanding of the role of a district engineer for a watershed district to encompass other professional disciplines that are involved in the design of watershed projects. In section 21, we're updating the purposes for which a watershed district may be established to bring them in line with current needs and consistent with other laws like the Wetland Conservation Act. In section 22, we're making a simple clarification of just one notice to the Department of Natural Resources rather than two, so it goes just to one office in the DNR. And we are also then, for Section 23, identifying where petitions for establishment of watershed districts can be made by resident owners, and clarifying in areas where it can be either 50 resident owners or 50% of resident owners, whichever is less. In Section 24, we are providing for mailed notice for hearings on these changes to be consistent with other provisions in the Act. In Section 25, we are enabling watershed managers to seek boundary changes along with the other eligible parties to petition for such changes. And we are also clarifying the notice that needs to be given for hearings on those changes. We're finally also providing that when an order is made to withdraw territory from a watershed district, that order needs to be filed with the appropriate authorities, including local authorities. Section 26 addresses a similar process for enlargement of a watershed district territory and clarifies, again, the notice provision to make it consistent with other provisions. And Section 27 makes clear, again, the appropriate officials that need to receive the order on a boundary change, including the local officials. Section 28 provides for a hearing to terminate the existence of a watershed district and requires that it clarifies where the hearing will be held on publicly accessible facilities, and also makes clear that each manager of the board of a watershed district is personally served with a copy of the order for that hearing. Section 29 concerns the establishment of a watershed district in more than one county and how the seats on the watershed board are allocated. This brings it in line with current practice in the Board of Water and Soil Resources to consider both the county's portion of the land area as well as their tax capacity. Section 30 provides for addressing equitable staggering of terms when positions are redistributed through the redistribution process in the statute. Section 31 provides that the petition to increase the number of managers can also come from the managers themselves, but it must be the majority of the board, not a majority of a quorum. Section 32, again, fills in missing details about orders and where they are filed and the findings that are required. There are several places, including Section 33, where we acknowledge the role of staff to receive certain notices or record of appointments in this case. And Section 34 concerns the convening of the first meeting once a watershed district is established. The current statute says that first meeting must occur within 10 days. We've extended it to 30. Section 35 is a provision that provides for calling of watershed meetings. We've made a change here to make it consistent with the open meeting law so that it is aligned directly with the open meeting law in Chapter 13D. Section 36 concerns the publicly accessible facilities for where a watershed district's principal place of business is located. And this clarifies that the principal place of business is defined as the location of the watershed district's office, or if it has no office, the location of its regular meetings. Section 37 concerns the appointments to an advisory committee to a watershed district, and we have added a representative of a federally recognized tribal government within the watershed district to expand the representation on the advisory committees. Section 38 acknowledges that watershed districts have the explicit authority to acquire property. This makes it also explicit that they can dispose of property which they determine no longer serves a useful purpose. Section 39 concerns the rulemaking authority of watershed districts. we make this change to be clear that the managers must adopt rules to accomplish their regulatory powers, which is the current practice and current interpretation of that section, but it makes it more explicit. Section 40 involves the surety or financial assurance available for a watershed permit. This clarifies that forms other than a surety bond can be provided. Section 41 makes explicit the requirement that watershed districts must submit an annual audit report within 180 days of the end of the fiscal year and submit that to the Board of Water and Soil Resources and the State Auditor's Office. Section 42 provides an explicit provision for removal of members of a watershed board and provides that after an opportunity for a hearing, the appointing authority, that being the county boards, may remove a manager by majority vote for violation of a code of ethics or for malfeasance, nonfeasance, or misfeasance. I should point out this identical language is already in Minnesota Rule 8410, and current law would also provide for removal for malfeasance, misfeasance, or nonfeasance. So this is putting it in the Watershed Act explicitly. Section 43 begins a series of significant changes to the planning process for watershed districts outside the metropolitan area. For starters, we should remember that Chapter 103B governs the planning process for metro watersheds, and so there's a number of references to the Metropolitan Council that is no longer relevant, and we propose that be deleted or repealed. We've also made clear in this section that it's not the Board of Water and Soil Resources that is the authority for developing the watershed district's plan. It is the watershed district with the review role of the Board of Water and Soil Resources. And I think I'll move beyond the planning section to get to the provision at 44 continues with the process for planning, and then that brings us to section 45. Again, a ministerial receipt of an appeal of an order going to the watershed administrator rather than necessarily a board member. Section 46 starts the changes made to project process for watershed districts. And this is a provision, I should say that all of these changes have been the product of more than 10 years of process with our member watersheds, including administrators, board members, and attorneys. And all of the changes that are before you have been through exhaustive discussions and do not involve any opposition from our membership. And the section that is most praised is this project simplification process, because we have inherited very cumbersome procedures for different types of watershed projects, and the remaining sections from 49 through 57 create a more streamlined process that make it clear that projects can be initiated by the watershed board, or they can be initiated by petition from local community members or local governments. And then it's clear about the process for which projects go through an engineer's or technical report process, design, hearings, and ordering, with explicit reference to the various types of funding for watershed projects, all within a coherent statutory scheme. With that, it's been a quick march, but I think you would be pleased to answer any questions.
Thank you very much, Mr. Smith, for that run through. Members, any questions or discussions? Yes, Senator Green.
Thank you, Madam Chair. Before I forget, I just wanted to mention that on the last section, the provision in here that really disturbs me is that now these local units of the SWCDs are going to be able to take out loans. I think that's a very, very dangerous thing to do. I don't even know why it's in there. But on this one, can you explain back on where you started on page 926? It says an engineer means an engineer or other professional. What other professional would be qualified to do this?
Mr. Smith.
Madam Chair, Senator Green, our watershed districts get involved in projects that certainly involve civil engineering, but also soil science, geotechnical work, so a variety of other disciplines. And so this is just a recognition that those other disciplines can also be involved in that process.
Senator Green, follow-up?
Okay, thank you. I'm not sure why you'd need that, but then on page 10, where on line 25, it says, to otherwise manage the project's surface waters and groundwaters for any beneficial purpose. It was added in. So there used to be stipulations as to what you can use, such as, different kinds of lands, marginal lands or high importance. But this one is just any beneficial purpose. So what does that mean? Does that, it seems to me like it could be as small as a blade of grass. I mean, what is the definition of any beneficial purpose?
Mr. Smith?
Madam Chair, Senator Green, that section is in the section of the statute for which a watershed district may be established, the various purposes. And these general purposes are about flood protection or mitigation, water quality improvements, and this section 14 that you've identified, to otherwise manage and protect surface waters and groundwaters for any beneficial purpose, is intended to be a comprehensive statement so that water-related beneficial purposes are within the purposes for which a watershed district may operate or be established.
Senator Green,
Thank you,
yes.
Madam Chair. For the record, the reason that is dangerous is we're dealing with stuff right now within the watersheds where we're seeing threats of eminent domain from watershed districts and the taking of private lands, the flooding of private lands when they can't make a deal. And so when you expand that definition to any beneficial purpose, it's going to lead to more problems for us, I think. I really don't like to see that. I'm just going to do one more on this section. On page 21, this might be small, but on 21.13, the existing language defines the Board of Water and Soil Resources. Is there a significance of why you took out Water and Soil Resources and just left Board?
Professor?
Madam Chair, Senator Green, in a word, no. Throughout the statute, the term board is defined as referring to the Board of Water and Soil Resources. So I think that's a collective judgment that the words of Water and Soil Resources is redundant, because that term board only means Board of Water and Soil Resources.
Okay, Madam Chair,
Senator
I did see one more question here.
Yeah, after
Okay,
you.
thank you. On 23, starting at number 4, where it talks about managers adopt a resolution. Upon adopting the requested resolution, the manager must release the deposit or bond required under the subdivision. And so this is, I believe, talking about being able to take money from other sources for projects, if I'm not mistaken. And so who would the other sources be? Are they NGOs, private groups, 501c3s? Is it so all of the above? So if that's the case, I see you nodding your head. So environmental groups can come in then to the local watersheds and give money for special projects that they might deem what they want. Is that what you're saying here?
Professor?
Madam Chair, Senator Green, first of all, the primary sources of funding that watershed districts would turn to would be perhaps state grants like clean water grants for the Board of Water and Soil Resources or other water quality related grants. Secondly, they might look to local partners, be it county funds or other local government funds, maybe a soil and water conservation district, in terms of partnership to get a project done. I am aware of some projects where nonprofit groups may have, conservation habitat objectives, but whether or not that money would be accepted and how it would be used would all be subject to the planning and process requirements of the Watershed Act, and it would only be accepted if the local watershed board found that it was appropriate.
Senator Green?
Okay, yeah, thank you, Madam Chair. And I will do one more, and then I promise I'll quit. I had more. But on page 24, starting at line 6, you've stricken some language there, too, for the determination. And some of the language that was stricken out here is the proposed projects or projects that promote the public interest and welfare. Why strike that out?
Mr. Smith?
Madam Chair, Senator Green, and I appreciate these questions very much. This language is only stricken because it's redundant. It appears elsewhere in the statute as rewritten.
Okay, thank you.
Members, are there any other questions? Is there any other discussion? And I should ask Senator Herr, does this complete your presentation of the bill? Are there any other people set to testify?
Madam Chair, this completes my presentation, and if there's no other questions, I would like to at least summarize and thank you, my testifier.
Yes, please go ahead.
Yeah, Madam Chair, there's a few more sections I could just quickly walk through with that continue on from the piece we just heard on Chapter 103D. Just so you know, the amendment includes the insertion of a 103E chapter provision, which is a consensus item on public drainage, which extends by 5 years a sunset date that's in that one particular part of statute. The next piece on section 59 makes two changes to the buffer protection law. It acknowledges the fact that the state authorization of the local official controls at a county or watershed district is an ongoing responsibility. On page, section, I'll go to section here instead, I'm sorry. Okay, section 60, right at the very top. These changes here, I'm going to not go through them each in detail because these are provisions of our Reinvest in Minnesota statute, a voluntary conservation easement program. These are provisions that are currently in state rule, and this bill is proposing to make these changes that are still important in the rule, bring them into the statute, and then repeal the rule. So we don't have a rule and a statute, we just have a statute. And there's also, of course, this program is reliant on state appropriations, and those appropriations from various funding streams also condition what those dollars can be used for. So with that, I'm going to just skip over to all the way, I think, then to section, chapter 103G is beginning on section 74 on page 38 of the current bill. And this has to do with the Wetland Conservation Act. Just a little bit of background, as Chair Herr noted in his remarks, is that in late May, after legislature adjourned, there was a Supreme Court case, Sackett versus EPA, which dealt with the waters of the U.S., and that affected the statutory jurisdiction of the federal authorities that are granted under that that federal law. That federal law is carried out in Minnesota by the Corps of Engineers and EPA in combination, and there are provisions in our state statute, our Wetland Conservation Act, which was first passed in 1991, which acknowledged that federal regulatory role, and we're going to continue that, but we have to make some changes to do two things. One, to try and align with the way the federal government defines and classifies wetlands, and secondly, to fill the gaps that loss of federal jurisdiction has revealed. That effort in this bill would be to basically bring us back to where we were in terms of total protection with federal and state law together before that Supreme Court case was rendered in late May. So I'm going to just walk through these changes in brief. The provisions in section 74 are to remove the details of a wetland classification typing system. That the document is still referred to, but we're taking out that specificity and adding a new and more updated version of wetland typing that is acknowledged by the federal government and we also at the state use. On section 75, there is a change being made to include that same definition at the top, but also to acknowledge that there are some areas that are deep water that are surrounded by shallower water that also have lost jurisdiction, and the state would take on a responsibility if the Corps of Engineers was not regulating those under this provision. If you turn to section 76, again, a few changes that are being made there to take out these wetland types, for example, on line 40.27, because that typing system is no longer lined up nor needed. And I'll see if I can roll this forward a little bit further onto, on section, so we're still in the same section here, these are longer sections. Section 77 on page 44, agricultural activities. What we're trying to do here is to take a disparate collection of exemption criteria and put them into one singular one, which rely on the USDA Natural Resources Conservation Service, who also protects wetlands that are on farmland that's enrolled in that federal program, to acknowledge and use their determinations for the wetland impacts that may occur there, or the wetland replacement that also occurs through our ag banking program, which we've done together. The condition and the amendment's got a couple of tweaks to make sure we do that correctly. Would require that the landowner allow the information to be shared, because that information currently is private information that the USDA only can share with the landowner. We'll go on to section 78. This is the drainage exemption. Again, there's a number of old provisions that are no longer relevant because so much time has passed since that 1991 statute was passed. The importance of drainage is still acknowledged here, and you can see on page 46, line 11, we're just consolidating this into one provision, which is that wetlands that are being affected by drainage maintenance, if they've been there for more than 25 years, will be subject to replacement, and if they're under that number, they would not be, and that's the current standard in Minnesota. I'm going to go to, I think I'll just go all the way to the next section, which would be section 79. There's a couple other changes on utilities, wild rice, and a couple other things where we're acknowledging the federal permit. If they get a federal permit that is going to condition the avoidance, minimization, replacement of a wetland, that will be acknowledged. So we try and keep it simple for landowners and local governments. On the bottom of page 47 in section 80, we have this, what's called the de minimis exemption, which is an amount that can be filled without replacement. You can see it was previously based on wetland type, and we are going to set that aside because the federal government doesn't acknowledge that, but instead use terms and criteria and measures that are more consistent with that federal authority while keeping the level of protection as the same under the state law, where it doesn't fill a gap that the federal government has revealed to us. And you can see the numbers here are being adjusted, not so much in amount, but in description. We go from square feet to acres, for example. On section 81, again, there are some changes to the evaluation of these wetland types in the technical documents that are used to make those decisions. That's consistent with current practice. On section 82 on page 51, there's a provision that sets aside this 60-day response, which is really important, mind you, but for these wetland banking projects, which are much larger things that take both local, state, and federal approval, we will set up a separate timeline for those, and that will serve everyone well, because otherwise they're just deferring or working around that timeline that is currently in statute. Bottom of page 51 in section 83, as I mentioned before, we have a wetland banking program for both standard developers types of uses. We have one for the agricultural circumstances, and we have one for the local road authorities, which has been really important to make sure those wetland impacts are replaced efficiently and ecologically beneficially. And then at the end of this section, on sections 80, 84, that is removed because it's an appropriation from this bill, and then the rest of it is revisor instructions and the repealer of the various statutory provisions in all the chapters, as well as the rules that were mentioned under the Reinvest in Minnesota program. Thank you, Madam Chair.
Thank you very much, Mr. Jaski, for going through all of those details in the various sections. With that, members, some more discussion or questions? Sure, Senator Wiesenberg.
Thank you, Madam Chair. I just had a question on section 74, page 38, where the wetland types are crossed out. Is just so I'm clear, the part that's underlined, starting on 38.6, that's right, find the new definitions. Is that correct?
Mr. Jaski?
Yeah, Madam Chair, Senator Wiesenberg, there's the types are being removed here. They arguably wouldn't have had to be in the statute in the first place, because those are the types that are actually described in that document that is referenced on lines 4 through 6 on page 38. The new and additional classification system doesn't use that same typing. It uses a more descriptive type of definition, but the types will remain. They just won't be used in the exemption section any longer.
Senator Riesenberg, follow-up?
Thank you.
Okay. Senator Green, to you.
Thank you, Madam Chair, and I only have a few left. One thing I want to ask before I make some comments here. I was asked about this. I didn't catch this myself, but on page 29, starting at line 26, talks about jurisdiction and not only the adoption but the implementation. And the question is this language actually taking some authority away from the watershed districts and the counties and on buffers and allowing Bowser to take control of that?
Madam Chair, Senator
After you.
Green, the current statute has a process where a watershed district or a county gets to elect the compliance responsibilities under this law, and they do so by adopting an ordinance in the case of a county or a rule in the case of a watershed district, and then that's evaluated by the Board of Water and Soil Resources, and if it's sufficient, then that is determined, and they go forward and have that responsibility. That will not change. If they choose not to do it, which a handful of them have chosen not to, then the state does the compliance work. This is simply saying that if a change is made to that ordinance, subsequent to our initial approval, then that has to be reviewed, and if it's sufficient, it will be, reaffirmed. If it's not sufficient, then the jurisdiction issue has to be reevaluated.
Senator Green.
Thank you, Madam Chair. So the answer is yes.
Mr. Jeske?
I can't remember the question, so I can't agree to the answer, Madam Chair.
Madam Chair,
Senator, if you wish to re-ask a question, please feel free to do so.
Is authority being transferred over for the implementation or basically enforcement of the buffer to Bowser with this?
Madam
Mr.
Chair,
Jeske,
Senator
if you would,
Green,
yeah.
No, we're just doing it the same way. The criteria are that if something changes in the ordinance or the rule, then it has to be reaffirmed, or if the ordinance or the rule is adopted but not implemented, then there has to be another reaffirmation. So it's an ongoing responsibility, not a one-time.
Senator Green, follow-up?
Okay, I'm just going to give a comment. Once again, there's just so much in this bill that disturbs me. It's expanding the powers of Bowser. And just to clarify, one of the comments that was made is that the county boards or the watershed boards are actually making these plans, these watershed plans, and Bowser's not doing them. They're just reviewing them. But if you read in the language, they are doing them because you're allowing the boards to make the plans, and then you look at the plans and say, no, do it again. And so in a sense, Bowser is writing these plans. And it's very disturbing. It's disturbing on a number of levels because, as I already stated, and I've had bills before to correct this, but watersheds are appointed. They're not elected, and yet they have taxing authority. That's taxation without representation. And this essentially looks to me like now our agencies are going to be tapping into that by telling the watershed boards what they can do with tax dollars. So, sorry, Senator Herr, I can't support the bill.
Thank you, Senator Green. Members, are there any other questions or discussion around the bill before I return back to the lead author? Okay. Senator Herr, would you like to make any comments as we close out the testimony on this bill?
Sure.
And discussion?
First and foremost, I'd like to thank Bowser and the testifiers and all the components and agency involved under this jurisdiction. And the agency, in most part, understand their own operation well, better than all of us. But at the same time, I'm glad that we do have good question coming forth and some disagreement in opinion, but some legitimate clarification, and I appreciate that. That's what we are here for, to make sure that our policy are transparent. And so the overall scope of this bill is to make sure that work and operation go on more efficiently. And so I'd like to ask members to support this bill. With that, I'd like to move that we refer Senate File 3559 as amended to be recommended to pass and sent to the Senate floor.
Thank you, Senator Herr. Members, Senator Herr moves that Senate File 3559 as amended be recommended to pass and sent to the floor. All those in favor, please signify by saying aye. 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 All those opposed, say no. No. The motion prevails. Thank you, Senator.
Okay. Next on our agenda is Senate File 3728, last item on our agenda today. So we welcome Senator McEwen to present Senate File 3728. You may proceed.
Thank you very much, Mr. Chair. First of all, as to Senate File 3728, I do have an A1 amendment. That amendment deletes Section 3 on page 7 and then amends accordingly. I would like to make that motion when the chair is ready to adopt the A1 amendment.
Okay, members, the author have the A1 amendment. Any question on the amendment? If not, let's see. All in favor of the amendment, say aye.
Aye.
Okay, opposed? Okay, motion prevail. Okay, Senator McEwen, on forward with your presentation.
Thank you, Mr. Chair. Senate File 3728 provides important policy language related to waste energy capture from wastewater treatment plants and related facilities. Minnesota state statutes currently lack some clarity to utilize this important energy resource. The proposed language is modeled after language contained in federal regulations. Additionally, this language proposes minimal changes to current state law and does not impact wastewater facility permitting or add an additional requirement. Senate File 3728 provides clarity to wastewater treatment plant operators that waste energy recovery from their facilities is supported and encouraged in Minnesota. Recently, the city of Duluth was awarded a Department of Energy grant to study and potentially construct a new district energy system that would deliver heating services to the Lincoln Park neighborhood of Duluth. The primary heating source that would serve Lincoln Park, which is a Justice 40 community, which if members don't know that this is a federal initiative to identify areas around the country that are underserved or traditionally disadvantaged, and the effort towards some of these federal monies is to specifically target the input of those federal resources into those neighborhoods that really have lacked resources for many years. So Lincoln Park in Duluth is one of those Justice 40 communities, and it would be a district energy system fed by waste energy captured from the effluent water from Western Lake Superior Sanitary District's wastewater treatment plant. Additionally, there is excess energy that could feed into the city-owned Duluth Energy Services District energy system. So this project would offer carbon-free energy for the Lincoln Park neighborhood and Duluth Energy Services current customers. So members, we're very excited about this possibility. As I understand, the Minnesota Pollution Control Agency has just offered some guidance around this issue as well, but we would like to proceed with the language of this statute in order to make sure that it is just very clear for all of the stakeholders that this is, again, something that we would like to support and encourage here in Minnesota. And with that, I also have someone here to testify in support of the bill as part of our presentation today.
Please introduce yourself.
Thank you, Senator McEwen. Mr. Chair, members of the committee, my name is Michael Auger. I'm Senior Vice President and Chief Business Officer of District Energy St. Paul and Evergreen Energy. Based in St. Paul, Evergreen Energy develops, operates, manages, and maintains district energy systems across the United States. I'm here to speak in support of Senate File 3728. Evergreen is currently engaged in 2 projects in Minnesota that would recover heat from wastewater and use it as an energy source to heat buildings via district energy system. One here in St. Paul, and as you've heard, one in Duluth. We're very excited to partner with the City of Duluth and WLSSD on that project and look forward to the potential that it has. In St. Paul, a similar opportunity exists. Since 2022, District Energy St. Paul has been working closely with the Metropolitan Council Environmental Services and the City of St. Paul to advance an opportunity to recover waste heat from the 180 million gallons of effluent water that flows every day from the Metro Wastewater Treatment Plant into the Mississippi River. The project would pipe wasted energy recovered from the effluent of the Metro plant and use that energy to further decarbonize 33 million square feet of building space served by District Energy St. Paul. This opportunity offers a unique possibility to recover wasted energy from Minnesota's largest wastewater treatment plant and use it in the United States' largest hot water district energy system serving downtown St. Paul, including this Capitol complex. While this scale of energy recovery from wastewater has been deployed successfully in Scandinavian countries, this would be the first time in the United States that effluent water would be utilized as a primary heating source for a district energy system. Both Duluth and St. Paul are applying for federal grant funds to advance these innovative and impactful projects. While it appears that energy recovery projects of this type may be allowable under current Minnesota law, the purpose of Senate File 3728 is to provide clarity that not only are these energy efficiency projects allowable, but encouraged, not required, allowed and encouraged. The language in Senate File 3728 is similar to what has long been in federal law to encourage the recovery and reuse of waste heat from wastewater. Senate File 3728 sends a clear message during a time of unprecedented federal energy grant opportunities that Minnesota supports implementing such energy efficiency projects that utilize wasted energy from public infrastructure. To give you a sense of the opportunity to do this elsewhere in Minnesota, there are over 800 municipally owned wastewater treatment plants. 800. Thank you to the committee for the opportunity to testify in support of Senate File 3728. I'd be happy to answer any questions you might have.
Member, any questions? Senator Green?
Thank you, Mr. Chair, and to the testifier, I guess. When I read the bill, that's the first thing I thought of. This can already be done, and so can you give me the reason why it isn't being done?
Mr. Auger?
Sure. Chair Herr, Senator Green, I think the reason that I know that the reason that this hasn't happened, we've had improvements in technology that have improved the coefficients of performance of ground source heat pumps. That is the performance when you're utilizing electricity to operate the heat pumps. We've also had similar projects that would utilize wastewater facilities that have run into hurdles of lack of clarity from the wastewater operators, not knowing whether or not they could do this. The guidance is helpful. Guidance can change over time. We're looking to formalize it in statute and make sure that that this policy is encouraged.
Senator Green, any follow-up?
Just one. What is the cost compared to just regular energy?
Mr. Auger?
Chair Herr, Senator Green, the cost is to be determined. Obviously, the wastewater energy or the wastewater facility operators are excited about the possibility of additional revenue. Those that would utilize it obviously would make the business judgment as to whether it was more cost-effective than other energy sources. When looking at alternative energy resources, they generally need to be at or cheaper than what's currently available. And that's what we're looking at with the projects that we're talking about.
Senator McEwen. Oh, no, sorry. Oh, what, McEwen? Senator Kunish.
Thank you, Senator Herr. I know it's getting late in the day. This just sounds like such an incredible opportunity, and I'm wondering if there are other communities or other areas in Minnesota that are considering this as well.
Now, Senator McEwen.
Thank you, Chair Herr, and thank you for this question, Senator Kunish. I'm actually going to ask my testifier here if he has any. He probably knows better than I do, and perhaps can speak to this. I don't know.
Mr. Auger.
Chair Herr, Senator Kunish, that's a great question. Not to my knowledge, but as I indicated, there are 800 facilities. There would be a variety of components that you would have to assess: how much energy is available, what is nearby that could be supported. But we like the opportunity that's there and are very excited about it. This is meant to be something that's scalable, not only here in Minnesota, but throughout the country.
Senator Kunish.
Sure. And then what sort of a environment is needed to make this kind of wastewater heat building possible? What do you need to have around it to make it successful, or could it be duplicated anywhere?
Chair Herr, Senator Kunish, again, looking at scalability, factors such as how much square footage is nearby to be able to heat, that's certainly a factor that we would look at. Is there an existing district system locally that could be tapped into and utilized? But you could also see this being a potential resource for the community that has the ability to do that and drive development utilizing low-cost, carbon-free energy as a attractive point for new development.
And one more question, please.
Senator Kunish.
This is, you know, I have no idea what it takes to create something like this, this whole program, but would this be the kind of opportunity to create really unique job opportunities in communities where there might not be them, and that you could move around with perhaps a really unique skill?
Mr. Auger.
Chair Herr, Senator Kunish, absolutely. Obviously, working on grant funding, you're looking at job-creating opportunities, not just the initial jobs of putting pipe in the ground, but also what is left for the community when this system is there. Certainly, that's something we'll look at both in Duluth and St. Paul and be a driver to help sustain jobs after the system is installed. And it could be something that then you can take and transition across the country.
Thank you.
Thank you. Any other questions from members? Okay, looks like this bill is good to go. Senator Morrison, can you move the Senate File 3728 as amended to be this layover bill? Okay, so this bill, Senate File, no need, thank you. This bill, Senate File 3728 as amended, will be laid over for possible inclusion. So thank you, Senator McEwen, and thank you, Mr. Auger, for to be here presenting to us on the district heating energy. Thank you very much.
Thank you very much.
Thank you.
So, member, this is near concluding of our business of today. Just a few announcements for the next committee hearing. This Thursday, we will have a full agenda. It may be long, and so we reserve this committee room up until 6 p.m. Thursday. So we hope that you can join us throughout to hear the bills ahead of us. So I'd like to ask my committee administrator to name some of the bills so you're aware of them. The bills already been posted publicly and online. So Carla Jofferson, can you list the bill for us?
Sure. Thank you, Chair Herr. This is Cara Josephson, Committee Administrator. As the Chair mentioned, all the bills are posted online. We will be hearing Senate File 3558, Public Waters Definition Modification, Senate File 3631, the DNR's Policy and Technical Bill, Senate File 3400, allowing the use of digital image permission as proof of possession of a game and fish license, Senate File 3730, Native Prairie Protection Opportunities Expansions Provision, Senate File 3393, the MLCAT, changes to the MLCAT account, Senate File 3561, the Packaging Waste and Cost Reduction Act, and that last bill will be last on the agenda as of now. That's the plan. So, thank you.
Thank you, Ms. Jefferson. Lastly, I also want to encourage members, if you have bills coming up, please submit as quickly as you can, because we're only had limited number of hearing before the end of this session. I think we already have two committee hearing already out of the 11, so there may be less than 9 to go. So if you have bills lined up, do make a request. So thank you all for joining us throughout this committee. And so I will adjourn this committee on today, February 20th. So the meeting adjourned.